The emergency ruling breakdown. This might sound like inside baseball, but consider this. The Supreme Court just issued a 6-3 emergency ruling that's sending shockwaves through Washington and every state capital right now. This decision could fundamentally reshape federal power versus state sovereignty. Before we break down what happened, hit subscribe so you never miss major Supreme Court news like this. Here's what actually went down late last night. The Supreme Court released a 6-3 emergency decision that directly challenges how federal courts have been operating for the past 2 decades. The majority opinion makes it clear that lower court judges no longer have the authority to issue nationwide injunctions that freeze state laws across all 50 states when only a handful of plaintiffs are involved in the case. Over the last 10 years alone, there have been more than 60 nationwide injunctions issued by single federal judges, effectively allowing one person in a black robe to override the will of entire state legislatures. What the Supreme Court just did was slam the brakes on that practice. And the timing couldn't be more critical given that we currently have 47 active cases across federal courts where states are seeking exactly these kinds of blanket injunctions. But here's what nobody's talking about yet, and it's the part that's going to cause the most controversy moving forward. The constitutional argument nobody saw coming. The constitutional reasoning behind this decision goes way deeper than most legal analysts expected. Justice Gorsuch's concurring opinion cites historical evidence from 1789 through 1850, showing that federal courts in early America never once issued an injunction that applied beyond the specific parties in front of them. He references 12 separate founding-era cases where judges explicitly rejected requests for broader relief, even when the plaintiffs argued it would be more efficient. This historical analysis matters because it suggests the entire practice of nationwide injunctions has zero constitutional foundation and has only existed because modern courts invented it out of thin air. Justice Thomas went even further in his separate concurrence, pointing to Article 3 of the Constitution and arguing that federal judicial power is inherently limited to cases and controversies, which by definition means specific disputes between actual parties, not abstract policy disagreements affecting millions of people who aren't even in the courtroom. The dissenting justices tried to counter by citing civil rights cases from the 1960s, but the majority basically said those cases were wrongly decided on this specific procedural point. What makes this particularly explosive is what it means for the 15 states that have already filed briefs relying on the old system. The immediate political earthquake. Within 3 hours of this ruling being published, attorneys general from 12 different states issued emergency filings in their ongoing federal cases. Texas cited the decision in 3 separate lawsuits challenging federal immigration policy. Florida referenced it in 2 cases involving election law and social media regulations. Arizona invoked it in a border security dispute that's been tied up in the Ninth Circuit for 8 months. The speed of these responses tells you everything you need to know about how significant legal strategists view this shift. What's even more interesting is the internal reaction at the Department of Justice, where, according to sources familiar with the matter, senior attorneys held an emergency conference call at 7 a.m. this morning to discuss how this affects their litigation strategy in 23 ongoing cases. The White House counsel's office is reportedly advising federal agencies to prepare for state laws they thought were blocked to suddenly start being enforced again, potentially as soon as next week in some jurisdictions. Republican governors are already announcing plans to move forward with enforcement of laws that have been frozen by injunctions, while Democratic state attorneys general are scrambling to figure out how to protect their residents from what they view as harmful policies in neighboring states. But here's the question everyone should be asking. If your rights depend on which state you're standing in when you assert them, do you really have constitutional rights at all or just geographic privileges? The answer to that question determines what happens with the massive doctrinal shift that's coming next, the litigation strategy revolution. This ruling completely rewrites the playbook for how legal battles get fought in federal court. For the past 20 years, advocacy groups on both sides of the political spectrum have used a tactic called forum shopping, where they file lawsuits in districts known to have sympathetic judges who will issue nationwide relief. The data on this is absolutely wild. Between 2017 and 2021, 78% of nationwide injunctions against federal policies were issued by judges in just 5 specific districts, even though those districts represent less than 4% of the U.S. population. The most extreme example was the Northern District of California, where 3 judges issued 19 nationwide injunctions in a 4-year period, more than the entire Fifth Circuit combined during this same time frame. Now that the Supreme Court has effectively killed this strategy, plaintiffs will need to file in multiple jurisdictions simultaneously if they want broad impact, which means litigation costs are about to explode. A case that previously required 1 filing in one friendly district might now require 15 or 20 filings across different circuits, with each one needing separate attorneys, separate arguments tailored to local precedent, and separate appeals if they lose. Major law firms are already sending memos to their clients explaining that civil rights litigation, environmental challenges, and constitutional cases could now cost 5 to 10 times more than they did last month. But what almost nobody has noticed yet is how this affects the one type of case where the stakes are literally life and death, the life and death policy implications. Let's talk about what this means for actual policy enforcement on the ground. Starting with the areas where the impact will be most immediate, immigration enforcement is the obvious flashpoint. With ICE currently operating under 14 different injunctions that limit various aspects of deportation policy, detention standards, and asylum processing. Under the new framework, many of those injunctions might only apply in specific districts, meaning federal immigration authorities could resume full enforcement in states not covered by those orders, potentially as soon as the lower courts issue clarifying rulings in the next 30 to 60 days. Second Amendment cases are equally affected with gun regulations in 6 states currently frozen by nationwide preliminary injunctions that prevent enforcement while appeals are pending. If those injunctions get narrowed to only protect the named plaintiffs, state officials could immediately begin enforcing firearm restrictions on everyone else, creating a situation where your Second Amendment rights effectively change the moment you cross the state border. Healthcare access represents another major pressure point, particularly around abortion medication, gender-affirming care, and religious exemptions to insurance mandates with 11 active cases where nationwide injunctions are currently preventing state or federal enforcement. Environmental regulations are similarly tangled with the EPA facing injunctions that block clean air rules, water protection standards, and climate-related regulations in ways that could now be limited to specific geographic areas rather than applying coast to coast. So, here's what you need to consider. If federal law can be enforced in Texas, but not California or vice versa based purely on where plaintiffs happen to file lawsuits, are we still operating as one country with one constitution? Or have we effectively created 50 separate legal systems? That question becomes even more urgent when you look at what's happening with election law right now, the election law time bomb. Election litigation is about to get incredibly complicated, and the timing of this ruling couldn't be more sensitive given that we're heading into a presidential election cycle. Currently, there are 9 nationwide injunctions affecting various aspects of voter ID laws, mail-in ballot procedures, early voting requirements, and voter roll maintenance in 19 different states. Under the Supreme Court's new framework, those injunctions might only protect voters in the specific counties where the plaintiffs live, meaning the same state law could be enforced in 80% of a state while being blocked in the other 20% based purely on where the lawsuit was filed. This creates an absolute nightmare scenario for election administrators who need to know months in advance what rules will govern their elections so they can train poll workers, print ballots, and set up voting locations. The National Association of Secretaries of State issued a statement this afternoon expressing serious concern about the operational chaos this could create if injunctions get geographically limited right before major elections. What makes this even more volatile is that both parties have relied heavily on nationwide injunctions to challenge election laws they disagree with, meaning both sides are losing a weapon they've used extensively. Between 2018 and 2023, conservative groups secured 8 nationwide injunctions blocking various election procedures, while progressive organizations obtained 11 such injunctions during the same period. With that tool now effectively gone, we're likely to see election rules vary dramatically, not just state by state, but potentially county by county within the same state, depending on the patchwork of limited injunctions that remain in effect. The question is whether Congress will step in to create uniform federal standards or whether we're about to experience the most legally chaotic election season in modern American history, the business and economic chaos. Corporate America is quietly panicking about this decision, and for good reason. Companies that operate in multiple states are suddenly facing the prospect of navigating 50 different regulatory environments where federal rules might be enforced in some places, but not others based on the geographic limits of various injunctions. The U.S. Chamber of Commerce estimates that compliance costs for multi-state businesses could increase by $47 billion annually if they need to maintain different operational standards in different jurisdictions based on which federal regulations are being blocked by limited injunctions in which districts. Banking regulations are particularly affected with three major rules governing cryptocurrency, lending standards, and consumer protection currently frozen by nationwide injunctions that might soon only apply in specific circuits. Technology companies are facing similar uncertainty around content moderation requirements. Data privacy rules and antitrust enforcement, where injunctions that currently provide nationwide clarity might soon create a state-by-state patchwork of requirements. Healthcare providers and insurance companies are looking at potential chaos around coverage mandates, prescription drug pricing, and telehealth regulations that could vary based on geography rather than being uniform across the country. The pharmaceutical industry is especially concerned about FDA enforcement actions with 5 current injunctions blocking various aspects of drug approval and monitoring requirements that might now only protect companies in specific jurisdictions, while leaving others fully exposed to federal enforcement. Employment lawyers are already telling their corporate clients to prepare for different workplace regulations, wage requirements, and anti-discrimination standards depending on where each facility is located and whether that location falls within the geographic scope of any limited injunctions. What's particularly frustrating for businesses is the uncertainty factor, since they won't know which injunctions survive under the new standard until lower courts revisit each case individually. The civil rights complication. This is where the philosophical rubber meets the constitutional road. And it's the argument that has legal scholars most divided. Civil rights organizations are expressing deep concern that limiting injunctive relief could force victims of discrimination to fight the same battle in dozens of different courtrooms before achieving nationwide protection. The NDACT Legal Defense Fund pointed out that during the civil rights era, nationwide injunctions were crucial in cases like Bruen versus Board of Education's implementation, allowing courts to prohibit segregation across entire states rather than just in the specific school districts where plaintiffs filed suit. If those cases had been litigated under the new framework the Supreme Court just established, desegregation might have taken decades longer, as each individual school district required separate litigation. Modern civil rights cases face the same challenge. When a state passes a law that allegedly discriminates against a protected class, should relief be limited to the handful of plaintiffs brave enough to come forward, or should it protect everyone in that class throughout the jurisdiction? The Supreme Court's majority opinion doesn't really address this tension, instead focusing purely on the Article 3 limitations on judicial power, regardless of the sympathetic nature of the claims. Disability rights advocates are particularly worried, noting that the Americans with Disabilities Act has been enforced largely through broad injunctions requiring systemic changes to government services, public accommodations, and employment practices. And it's unclear how effective enforcement would work under a regime of plaintiff-specific relief. Here's the fundamental tension. If preventing harm to vulnerable populations requires broad injunctive relief, but the Constitution limits courts to resolving specific disputes between specific parties, which principle should give way and who gets to make that decision? That question leads directly into what might be the most significant aspect of this ruling that almost nobody is discussing yet: the Supreme Court power play. What's really happening here is the Supreme Court reasserting its own authority over the entire federal judiciary, and the implications of that power move extend far beyond injunctions. By issuing this ruling through the emergency docket rather than waiting for a full case with oral arguments, the court sent an unmistakable message that it expects lower courts to comply immediately, not after years of additional litigation. This represents the culmination of a pattern where the current Supreme Court has become increasingly willing to use its shadow docket, emergency orders, and summary reversals to control how lower courts operate. Statistical analysis shows that the court has issued 47 emergency orders in the past 3 years that modified or vacated lower court decisions compared to just 19 such orders in the previous 3-year period. What makes this particularly significant is that emergency orders typically don't include full reasoning or extensive legal analysis, meaning lower courts are expected to comply with broad principles without detailed guidance on how to apply them in specific factual situations. Several appellate judges have privately expressed frustration with this approach, suggesting it creates more uncertainty rather than less, because they're forced to guess at what the Supreme Court wants rather than having clear presidential guidance. The practical effect is that the Supreme Court is micromanaging federal litigation in ways that were unthinkable 20 years ago, stepping in on emergency basis to overrule district judges, circuit courts, and even state Supreme Courts when the current majority believes those courts have exceeded their authority. This ruling on nationwide injunctions fits perfectly into that pattern. It's the Supreme Court telling hundreds of federal judges across the country that they've been doing their jobs wrong for 2 decades, and they need to change their approach immediately. Whether that represents appropriate appellate oversight or judicial overreach depends entirely on your perspective about how the federal court system should function. But either way, it's a remarkable assertion of power that's reshaping the entire judiciary from the top down. This Supreme Court ruling changes everything about how federal power operates in America, and we're just seeing the beginning of the fallout. If you want to stay informed on major legal developments like this, make sure you're subscribed, hit the like button, and drop a comment with your thoughts on this decision.